फर्स्ट अपील है तो
फर्स्ट अपील है लिस्टेड अंडर द हेडिंग ऑफ ऑर्डर्स।
क्यों बोले फर्स्ट?
वो सेक्शन 30 का था वो जो
हाँ क्या हुआ?
तो चूंकि यहाँ से हमने दिया था तो कोर्डिनेट बेंच में गया था, वहाँ उन्होंने कहा कि एक्जीक्यूटिव कोर्ट प्रोसीड, और उसके बाद फर्स्ट अपील देने के लिए सेक्शन 30 का
नहीं, ये तो वही है ना जो इंस्टीट्यूट नहीं हुआ कि क्या हुआ क्या?
एक आदेश था कि अपना सिक्योरिटी लेकर और जो भी लेकर वो रिलीज करें अमाउंट।
हाँ।
तो उसके यही इन्होंने एप्लीकेशन उसी को डाला था।
हाँ फिर क्या हुआ?
उसमें इन लोगों ने एक रिकॉल पिटीशन बीच में डाला था कि जो ऑनरेबल सिंगल बेंच का जो ऑर्डर्स
तो क्यों नहीं अप्लाई कर रहे हैं आपके ऑफिसर?
वो डिसमिस हो गया इनका।
वो डिसमिस हो गया हमारा ये विद डायरेक्शन दैट एक्जीक्यूटिव कोर्ट शुड प्रोसीड।
हाँ तो फिर
तो प्रोसीड करिए।
तो लेकिन तो ठीक है, एक्जीक्यूटिव कोर्ट प्रोसीड करेगा।
तो डायरेक्शन था ना पैसा जमा करने का एग्जीक्यूटिव कोर्ट में।
हाँ
तो आपके अपने पास क्यों पैसा रखे हुए हैं? आपके घर का पैसा है?
नहीं सर, पैसा
फिर कैसे?
एग्जीक्यूटिव कोर्ट में बोल के पैसा जमा कराइए।
सेक्शन 30
क्यों नहीं कराए? कहाँ है ऑफिसर? बुलाइए। आ रहे मतलब क्या? मेंशन कर रहे हैं, आप भी बहस कर रहे हैं, आ रहे हैं। क्यों लेट है? नाश्ता कर रहे हैं?
नहीं दिस लेटर थोड़ा जस्ट ये टेलीफोनिकली
मेंशन कर दीजिए।
नहीं हम
अब हमको जब मन होगा तब करेंगे टिकट। जब होगा 4:30 इन यूजुअल कोर्स इट विल बी टेकन
एज योर लेडीज से नहीं वो इसको
जो बंदा लेट हो गया वो लेट हो गया।
नहीं कुछ ठीक है।
तो आइटम नंबर 36
हम भी लेट
रेगुलर टाइम पे जब भी टिकअप होने वाला होगा कॉल आउट होगा, उस समय नहीं अपीयर होंगे तो वी विल सी व्हाट इज टू बी डन। उनको बोल दीजिए जहाँ भी है ना
पहुंची मतलब जस्ट इन्फॉर्म टेलीफोनिकली और चौक पर धन्यवाद सर, थोड़ा रांची से नहीं दूर से धन्यवाद नहीं, अदरवाइज आई वुड नॉट हैव मेंशन।
The 36 item number, my lord, the daily cause issue, that will for orders. उसमें ये 3-4 हफ्ते से चल रहा था, लेकिन वहाँ एक्सक्यूशन का प्रोसीडिंग स्टार्ट हो गया।
ऑर्डर्स में क्यों है?
ऑर्डर्स में चूंकि इसको रखा गया था फाइनल डिस्पोजल के लिए, मीन टाइम ऑफिस रिपोर्ट किया कि एक रेस्पोंडेंट को नोटिस सर्व नहीं हुआ, बट इट वाज वैलिड सर्विस।
ऐसा थोड़ी ऑफिस अगर नोट कर रहा है
कंपनी को नोटिस था, तो बट कंपनी हैज रिसीव्ड द नोटिस ऑन बिहाफ, रिप्रेजेंटेटिव हैव रिसीव्ड द नोटिस, तो उसको इग्नोर करके
नहीं अभी देखते हैं। सो ऑर्डर्स केस 4 बजे होता है, उसी समय आइए, उसी समय मेंशन करिए।
From supplementary list case item 3 second appeal 484 of 1991.
Record details. Exhibit 14 by 14 by Exhibit 1. the learned counsel appearing on behalf of the parties. इसमें एक आईए है आपका, ये डिस्पोजल हो चुका है 9453/2025 deleting the name of 1A. आप बैठ जाइए। This appeal has been filed against the judgment and decree dated 37/1991, passed in title appeal number 25/84 by the second additional district judge Dumka, reversing the judgment dated 5/4/1983 within bracket judgment and decree dated 5/4/1983 passed in statute number 18/1981. The suit was dismissed on contest, which was reversed by the first appellate court. Consequently, the defendant is the appellant before this court. This appeal was admitted for final hearing by order dated 28/1992 on following substantial question of law: whether the marriage in Ogumit form can be equated with Ghajamite form of marriage among the Santhals. The learned counsel for the appellant has submitted that it is not in dispute that parties are governed by Santhal custom, he has submitted that the suit was filed for declaration of plaintiff's right, title and interest in the suit land, and also for delivery of possession he has further stated that ध्यान देंगे. He has further stated that the custom in the custom governing the parties was stated in Schedule D of the plaint, and has वही चौधरी वाला गैंगस्टर्स नहीं, एक चौधरी वाला कल एक और कोई बुक आप साइड कर रहे थे, क्या बुक था? आप लोग चाहिए मंगा लीजिए, देखते हैं वो क्या बुक था, हमको थोड़ा देखना है. The Learned Council has submitted that Gharjamai form of marriage is totally distinct from Ogumit Gharjamai. The Learned Council has submitted that as per the case of the plaintiff, the genealogical table has been given in paragraph 2 of the plaint, and the land of JB number 32 of village Madhuban corresponding to land of JB number 4 of village Madhuban of Macpherson's settlement belonged to the common ancestor, namely Chukuru Tubu. The properties of JB number 32 was described in Schedule A of the plaint, which was recorded in the name of Bhaglu Hansda and Roman Soren. And it has been stated in the plaint that they were Sarhus, S-A-R-H-U-S. Churka Tudu had no sons but two daughters. Eldest one was married to Bhaglu Hansta of village Pakulia, and the second daughter was married to Raman Soren of the neighboring village Kundalpang. On death of Chakru Tudu, the property was inherited and possessed by his daughters and son-in-law as per Santhal customary law of inheritance. The further case of the plaintiff was that the land of JV number 32 was partitioned and one share was allotted to Bhaglu Hansta and his wife, another was allotted to Raman Soren and his wife, and they were separated. It was also asserted that during gangster settlement operation, the brother of Chakru Tudu and some others objected and claimed the land, but their claim was disallowed and the property was ultimately recorded in the name of Bhaglu Hansa and Raman Soren. The property recorded in the name of Bhaglu Hansa was described in Schedule B of the plate. And upon his death, it was inherited by his three sons. They were Karan, Ram, and Lakhan. Full stop. Karan died about 15 to 16 years ago, leaving behind his three sons, Ruplal, Choto, and Nunulal, semicolon. Nunulal also expired about 6 years ago, leaving two minor daughters, Maruti and Kaha, semicolon. Ram Hansa died in the year 1968, leaving the plaintiffs as his heirs and successors. Lakhan died in the year 1969, leaving Vibhishan Hansa and Srinath alias Nath Hansa. The plaintiff number 1 is Surajmani Hansa, who is the daughter of Ram Hansa, correct? Ram Hansa की बेटी है, Ram Hansa. Plaintiff number 2 is the husband of plaintiff number 1, and plaintiff number 3 and 4 are the sons of, were the children of plaintiff number 1 and 2. It was further case of the plaintiff that the property in Schedule B was partitioned in 3 shares, one each to Karan, one share to Karan, another to one each to Karan, Ram and Lakhan, and all were separately possessing the land and paying rent, sometimes jointly and sometimes separately. However, the lands of Ram Hansta was described in Schedule C to the plaintiff. It was the case of the plaintiff that plaintiffs are residing in plot number 532 in the property allocated to Ram Hansta. Ram Hansta had no sons. The specific case of the plaintiff was that Ram Hansta brought his daughter Surajmani and her husband Devi Murmu in Ogumit in the year 1957 BS, which is equivalent to 1951. 1950-51. तो देख के बताइए, which is equivalent to 1950/51,
1957.
and entrusted the cultivation and household affairs to them. Ram Hansa thereafter, on 9 Asad 1357 BS, executed a Gharjamai paper in presence of villagers, signed by him and the villagers, including the father of defendant number 1 and 3. And since that time, the plaintiff number 1 and 2 have been living in the house of Ram Hansta and have been cultivating the land. And the plaintiff number 3 and 4 were born in the house of Ram Hansta, where they are living. It was further case of the plaintiff that during the lifetime of Ram Hansta, the plaintiffs helped him in cultivation of his land and manage all the affairs of the family. And it was the specific case that upon death of Ram Hansta, the property was inherited by the plaintiffs as Gharjamai, coupled with other customary law of inheritance, whose particulars are given in Schedule D. The cause of action arose when the defendants, being the admits, started disturbing the possession of the plaintiffs, a proceeding under section 107 CRPC and another under section 144/145 CRPC was initiated, and it was their case that on 24/12/1979, after the order dated 24/7/1979 decided against the plaintiff, the defendants forcibly dispossessed the plaintiffs from the suit land and demolished some of the ridges within bracket AIL bracket close, of their land. It was claimed that the plaintiffs were the rightful owners of the small property. The learned counsel has submitted that so far as the defendants are concerned, they had filed a joint written statement was filed by defendant number 1 to 6. Stating that 5 to 6 wherein the genealogy etc. and the name of the common ancestor was admitted. However, it was stated that the daughters of Turku Tudu were married in Gharjamai form and therefore their husbands were recorded under JV number 32 during gangsters settlement operation with a separate area in the remarks column. It was their further case that Ram Hansda was one of the sons of Bhaglu Hansda, but he predeceased his father. And so after death of Bhaglu Hansda, his two surviving sons, Karan Hansda and Lakhan Hansda, inherited the entire land. And therefore it was denied that after death of Bhaglu Hansda, he had 3 sons. It was further stated that Ram Hansda died in the year 1940, leaving behind his only minor daughter, plaintiff number 1. And Bhaglu Hansda, the recorded tenant, died in the year 1960. And after his death, 2 surviving sons, Karan Hansda and Lakhan Hansda, died in the year 1965 and 1969 respectively. It was asserted that Ram Hansda, the father of the plaintiff, did not succeed Bhaglu Hansda. It was their further case that the land recorded in the name of Bhaglu Hansda was never separated, and Karan Hansda and Lakhan Hansda were still in joint possession. And their successors were still in joint possession. It was stated that at the time of death of Ram Hansda, the plaintiff number 1 was a minor girl, and therefore Karan and Lakhan look after her and got her married in ordinary form with one Sadhu Marandi of village Dumi. However, plaintiff number 1 was divorced. Plaintiff number 1 divorced her husband and remarried with Devi Murmu of Agod Jotri. And thereafter the plaintiff number 1 with plaintiff number 2 and plaintiff number 3 and 4 have been living in the village Agojotri. It was a specific case of the defendant that, in view of the aforesaid facts, the plea of Ogumit in 1357 BS and entrustment of land to plaintiff number 1 and 2 and execution of Gharjamai paper was bogus and false. And any Gharjamai paper in possession of the plaintiff number 1 and 2 is a forged and fabricated document. It was a further case that the plaintiffs have never been living in the village Madhuban, nor they have ever cultivated any land of Jamabandi number 32 of Mauza Madhuban. It was their case that Ram Hansdar could not succeed his father, and therefore the question of succession of the plaintiffs did not arise. The Schedule D of the plaint is quoted as under. The learned counsel for the appellant has submitted that the learned trial court held that the plaintiff was married to plaintiff number 2, Devi Murmu, in Sada, Saga or Chumman form, which was never converted into Ogumit Gharjamai as asserted by the defendants. And the issue was decided in favor of the defendants and against the plaintiff. However, the learned first appellate court has reversed this finding and has held that plaintiff number 1 was married with plaintiff number 2 in Ogumit Gharjamai form. The learned counsel has submitted that so far as the claim of partition amongst Ram Hansta and his 2 brothers are concerned, the same was disbelieved by both the courts. he has further submitted that so far as the document of Gharjamai Exhibit 1 is concerned, the same was disbelieved by the learned trial court, but this finding was reversed by the learned first appellate. The learned counsel has submitted that Gharjamai form of marriage and Agumit Gharjamai are two different concepts, and since the plaintiff had pleaded the custom, it was for the plaintiff to prove the same. He has submitted that the plaintiff has miserably failed to prove the custom. The learned counsel has relied upon a judgment passed by Honorable Patna High Court reported in 1984 SCC Online Patna 211. And has submitted that and has referred to paragraph 30 of the said judgment to submit that there is nothing like Agumit Gharjamai form of marriage in Santhal custom. And has also submitted that and has also referred to paragraph 31 to submit that the Santhal tribal law is quite definite for not allowing female to inherit, but the law was gradually changing in some of the areas whereby Santhals had allowed daughters to inherit along with sons. The learned counsel submits that the change in customary law was required to be proved by the plaintiff in order to claim inheritance, but the plaintiff has miserably failed to prove the same. That's all. The learned counsel for the respondents, on the other hand, has placed the judgment passed by the learned first appellate court and has submitted that कल आप कोई पैराग्राफ रेफर कर रहे थे बताइए कौन सा पैराग्राफ
7 to 14
and has referred to paragraph 7 to 14 of the first appellate court's judgment, the learned counsel has submitted that every aspect of the matter has been discussed by the learned first appellate court while reversing the decree. He has submitted that, as recorded in paragraph 7 itself, the custom as mentioned in Schedule D was not specifically denied in the written statement. Rather, the case of the defendants was that the case of the defendants was that there has been no argument with respect to the plaintiff number 2 and the Kharjamai paper, that is exhibit 1, was forged and fabricated.
एक पैराग्राफ और एप्लेट कोड का इसमें एक पैराग्राफ 22 of the appellate court, page number 23. Page number 23, appellate court, internal basis.
In response, the learned counsel for the appellant has referred to paragraph 22 of the appellate court's judgment and has submitted that one of the precondition of Kharjamai marriage is that the boy has to leave his parental home and property and relinquish his property of his parents. But the plaintiff herself deposed that her husband owned some property in village of Jori, which is his parental village. After hearing the learned counsel for the parties, this court finds that as per the plaintiff, there is a well-settled custom prevailing in the locality that married daughter with her husband, even with their children, can be brought to the house of her father and be settled permanently. And this is known as Ogumit Ghajamai, and in such Ogumit Ghajamai, on the death of father-in-law, his property passes to son-in-law, as in the case of Ghajamai form of marriage. Thus, the custom as pleaded reveals that for Ogumit Ghajamai is an act which takes place after marriage and is different from Ghajamai form of marriage, which takes place and is different from Ghajamai form. The specific case of the plaintiff was that defendant number 2 was that Ram Hansda brought defendant number 1, his daughter, and defendant number 2, his son-in-law, in Ogumit in the year 1357 BS and entrusted the cultivation and household affairs to them. And their further case was that Ram Hansda thereafter on 9th Asar 1357 BS executed a Ghajamai paper in presence of villagers signed by him and villagers including father of defendant number 1 and 3. And since then, plaintiff number 1 and 2 have been living in the house of Ram Hansda and have been cultivating the land, and the plaintiff number 3 and 4 were born in the house of Ram Hansda. It was their case that after death of Ram Hansda, they inherited the property as defendant number 2 was brought in the family of Ram Hansda by Ogumit. The defendants, on the other hand, opposed the aforesaid stand by asserting that the plaintiff number 1 and the plaintiffs have been living in the village of plaintiff number 2 at Agojori. The defendants denied the plea of Ogumit and also denied the execution of Ghajamai paper. However, so far as the custom of Ogumit form, the custom of Ogumit has not been denied, specifically denied. This court finds that at the stage of trial, both the parties adduced oral and documentary evidences with respect to the following issues. 1357 BS होगा 1950 equivalent. Page number 9 of trial court judgment में issues. The learned trial court, while deciding issue number 4, recorded that as per Santhal customary law of inheritance, girl married only in Ghajamai form is entitled to inherit her father's property, and in case of Chumman or in ordinary form is not entitled to inherit. It was also observed that as per case of the plaintiff, Ram Hansta had brought defend number 1 and 2 in Ogumit Ghajamai in the year 1357 BS, corresponding to 1951, 1951, and executed Ghajamai paper exhibit 1 on 9 Asar 1357. The learned trial court considered the evidences, oral evidences, which also referred to Ogumit Ghajamai form However, the learned trial court in paragraph 22 observed that the plaintiff have based their claim purely on custom, but they have not proved the custom. ये submission है लगता है. This is not. That is just the last. The learned trial court ultimately held that the plaintiff Surajmuni was married to plaintiff number 1 was married to plaintiff number 2 in Sada or Chumman form of marriage, which was never converted into Augment Gharjamai as asserted by the defendants. The Exhibit 1, which was the Gharjamai paper, said to have been executed after plaintiff number 1 and 2 were taken by Ram Hansta in augment form, was disbelieved by the learned trial court. So far as issue number 2 and 3 is concerned, the trial court held that there has been no partition between the 3 sons of Bhaglu Hansta, and Ram Hansta predeceased his father Bhaglu Hansta as alleged by the defendants. This finding has been recorded in paragraph 33 as follows. Para 27 को quote करने trial court para 33 को भी quote करने. So far as issue number 5 is concerned, the learned court ultimately held in paragraph 37 that the plaintiffs failed to prove their possession over the suit land as alleged and their dispossession as alleged. And while deciding issue number 1 and 6 held in para 38 that the plaintiff has got no valid cause of action, and ultimately the suit was decided against the plaintiff and was dismissed. So far as the learned first appellate court is concerned, the points for determination have been mentioned in paragraph 6 as under. While deciding the most important issue, it concerns the substantial question of law in this case, is issue number 4. Is point of determination number 4, which has been decided by paragraph 7 onwards. The learned first appellate court has taken note of the fact that in Schedule D of the plaintiff has enumerated one of the customs of Santhal, that is Augment Gharjamai, whereby the properties of father-in-law passes in the hand of son-in-law after the death of the former, as in the case of Gharjamai form of marriage. And observe that there is no specific denial of this custom in the written statement. The learned court thereafter considered the materials on record and referred to the गैंगस्टर्स सर्वे रिपोर्ट. कहाँ है वो आपका किताब? पीसी राय चौधरी है वो. The learned court has also considered the Bihar District Gazetteer Santhal Pargana by P.C. Roy Chaudhary. Wherein at page number 951, it has been recorded as under quote. The father, in default of a son in the old age, can create an augment, comma, that is bringing of the married daughter with her husband to his own house, full stop. After the death of father, his property passes as Gharjamai form of marriage. And ultimately held that it was proved that in Santhal custom, son-in-law in case of augment form is entitled to succeed to the properties of his father-in-law. Such finding has been recorded in paragraph 14 of the appellate court's judgment. 13 and 14, ये दोनों कोट करें. It is also important to note that the learned first appellate court considered Exhibit 1, which is the paper of Gharjamai, as the most important evidence on record and dealt with its genuineness in paragraph 19 onwards, and ultimately held that The learned trial court has wrongly held that the Garjamai paper was forged and fabricated. This is the document which was executed by Ram Hansda in favor of plaintiff number 2 on 9th Asar 1357 BS, in which, besides others, Lakan Hansda, father of the defendant number 1, and Karan Hansda, father of defendant number 3, had also put their signature. And observe that Lakan Hansda and Karan Hansda were full brothers of Ram Hansda. To this fact, there was simply a vague denial in the written statement. The learned court ultimately held that the document of Garjamai within bracket exhibit 1 was a genuine document. The learned court also considered the deposition of PW1, who admitted in paragraph 17 of her evidence that her husband Devi Murmu owned some land and village, Ogojori, which is his parental village. On the basis of which it was submitted by the learned counsel for the respondents before the first appellate court that it meant that Devi Murmu had not relinquished his share in his parental property. The learned court recorded that PW1 had not stated that PW1 had not stated that plaintiff number 2 had succeeded to the properties of the father at village Agojotri. And there was no legal bar if the Garjamai or Ogumit Garjamai acquires some property in the original village home of his father. The learned first appellate court ultimately held in paragraph 23 that plaintiff number 1 was married with plaintiff number 2 in Ogumit Garjamai home, and the finding of the learned trial court was incorrect. The learned court also recorded in paragraph 28, considering the evidence on record, that the case of the defendants that Ram Hansda had predeceased his father was not proved. Contrary finding of the learned trial court was held to be wrong. Further, the learned court in paragraph 29 referred to Gangster's report on the point of succession, as the plea of partition was plea of previous partition was rejected, and ultimately decided the share of the plaintiffs to the extent of 1/3. This court finds that so far as the substantial question of law as to whether the marriage in Ogumit form can be equated with Khatimai form of marriage amongst Santhal is concerned, it is crystal clear from the discussions above, particularly the gazetteer report by P.C. Roy Chaudhary at page 951, that the father in default of his son in old age can create Ogumit by bringing a married daughter with her husband, meaning thereby the Ogumit happens with respect to a daughter who is already married. And so far as Gharjamai form of marriage is concerned, the same is a different concept. It has been observed therein that in case of Ogumit, after the death of the father, his property passes as Gharjamai form of marriage, meaning thereby the status of the passing of property in case of Ogumit and also in case of Gharjamai form of marriage is consequently it is held that the taking of the daughter and her husband in Ogumit form is not the same as performing their marriage itself in Gharjamai form, but as per the Fused Gazette report, they acquire the same legal status so far as inheritance is concerned. This is over and above the fact that the learned First Appellate Court has held that Exhibit 1, which was the document of Gharjamai, was duly proved, in which none less than the father of the defendant number 1 and the father of defendant number 2 were signatories. After having held that Ogumit form is different from marriage in Gharjamai form, however, while answering the substantial question of law, but so far as the claim of inheritance of the plaintiffs is concerned, the same remains undisturbed in view of the findings recorded by the learned First Appellate Court, taking into consideration the materials on record, including the Gazette publication of trial charge. Consequently, this appeal is hereby dismissed. To the next.
Supplementary list. for final restore item 1, second appeal 185 of 1995.
This case was, मैं informed you lordship, Huzur Lords, इसमें respondent सर से कुछ मर गए हैं, उसका पता हमको केस नहीं है, हमको लीगल एयर्स है, पता नहीं।
किसमें?
इसी केस में, इसी केस में।
कल सुनने के पूरा बाद?
हाँ? इसका सुनाई नहीं, दूसरा केस है।
अच्छा
फर्स्ट केस सप्लीमेंट्री का है।
अच्छा, आइटम 1, ठीक। हाँ, क्या किसका डेथ हो गया?
प्रॉपर पता नहीं है, सब्स्टिट्यूशन के बाद जब आए थे तो पता चला। प्लांट नहीं मर गए थे, सब्स्टिट्यूट हुए।
आप नाम बताइए ना, कौन मर गए हैं?
बाबूलाल मुर्मू का 2 लड़का जो सब्स्टिट्यूट हुआ था, 4 हुआ था, इसमें 2 लड़का था, तो दोनों लड़का जो है उसका डेथ कर गया। यही इन्फॉर्मेशन तो इनको पता है।
आप दे रहे हैं?
पता नहीं, नाम नहीं पता, कुछ नहीं
पता
पता।
लगा लीजिए, तो आप सब्स्टिट्यूट हैं, आप लोग रिलेशन है, उसी फैमिली से
इन्फॉर्मेशन
मिल जाएगा।
पता नहीं।
आपके पास नहीं है क्या इन्फॉर्मेशन?
हमको ये पता लगा कि ये 2 आदमी मरा है, एक मर
ये-
गया है।
ये कौन सा आइए पढ़ रहे हैं आप?
ये आइए नहीं, इनको अब ये जो मरे हैं, तो वो बाबूलाल मुर्मू जो रेस्पोंडेंट नंबर 1 थे, उनका सब्स्टिट्यूटेड एयर्स था 2। एक था निशिकांत मुर्मू, जिसका नाम चेतई मुर्मू था, एलियस चेतई मुर्मू, और दूसरा था छोटा बरसन मुर्मू, एलियस चुताई, चेतई और चुताई।
क्या हुआ इसका रिपोर्ट?
ये दोनों का डेथ हो गया है।
रिपोर्ट अवेटेड।
आइए नंबर 263 ऑफ 2003 में सब्स्टिट्यूशन क्वेश्चन पढ़ा था, इसका ऑर्डर पास हुआ था 4 को। एप्लीकेशन फाइल कीजिए।
भाई, हमारे रिकॉर्ड से कैसे पता चलेगा किसका डेथ हो गया? कुछ फाइल
आपको
किया है आपने?
हमको इंफॉर्मेशन दे रहे हैं।
वैसे कुछ फाइल करके तो नहीं दे रहे
नहीं
हैं?
नहीं, the order, the information can be deemed to have been made under order 22 rule 10.
ऑर्डर 22 रूल 10 का सर
10
पिटीशन
में-
पड़ता है।
Leaders
ऑर्डर
will
22
be-
रूल 10 का पिटीशन पड़ता है, जिसमें इंफॉर्मेशन ऑफ डेथ भी रहता है और साथ में उसके लीगल ईयर्स का डिटेल भी रहता है।
नहीं, ऐसा नहीं है। उसको देखा जाए, हमको ड्यूटी का है कि हम लीडर्स को कह दें, कोर्ट को
CPC
इंफॉर्मेशन दे दें, तो
इसमें और भी पता चला है,
4
और 5 भी मर गए, रिस्पॉन्डेंट भी मर गए।
वो 2 और उसका
4 और 5।
जो है आपके खैर जो भी है, इनको इंफॉर्मेशन जो है वो दिया जाएगा। उसी गाँव के
बुद्धू मुर्मू कौन है?
बुद्धू मुर्मू थे, said to have been adopted by Munshi
रेस्पोंडेंट नंबर, रेस्पोंडेंट है, अपीलांट है कौन?
बुद्धू तो एप्लेंट थे,
ये तो प्लांट है
नहीं थे,
थे मतलब
थे नंबर गए सब्स्टिट्यूट हुए हैं।
सब्स्टिट्यूट हो चुके हैं।
जी
अभी तो रिसेंटली आपके ऑर्डर से हुआ है।
7-8 तो 7-8-2025।
ठीक है, उनका तो हो गया सब्स्टिट्यूशन। अब कौन मर गए?
अब तो ये 2 नया बात हो
अब
गया।
कौन मर गए?
इनके जो बाबूलाल और वर्षन मुर्मू, इनके पीढ़ी,
अरे रेस्पोंडेंट नंबर कुछ बताइए ना, ऐसे नाम से बताते हैं।
इनके
Respondent
लीगल
number-
इनके लीगल हेयर्स हैं, वो भी
किन के लीगल ईयर?
बाबूलाल और वर्षन है, और रिस्पॉन्डेंट नंबर 4 और 5 ये भी बने।
रेस्पोंडेंट नंबर 4 and 5
5
बुद्धू मुर्मू एंड रक्षा मुर्मू।
जी
इन्हीं का लिखा रहे हैं, आपका गलत स्टेटमेंट नहीं
नहीं,
होना
पता
चाहिए।
नहीं है,
95 का
पता-
केस में आप इस तरह से
पता
सबमिशन नहीं कर
है,
सकते।
प्रॉपर पता नहीं तो अपने
पता नहीं है तो बहस करिए।
पता
नहीं मतलब क्या?
नहीं, इधर भी मर गए हैं, जो सब्स्टिट्यूट हुए थे उसमें भी मर गए।
अरे भाई नाम बताइए, आप रिस्पोंडेंट बताइए कौन मर गए हैं। ये सब तो एक ही जैसा नाम है इसमें, आप हमको बताइए कौन मर गए हैं, बताइए।
प्रॉपर आइडिया नहीं है तो
कोई आइडिया नहीं है, ठीक है। आपको जो फोन करते हैं ना कि ये मर गए हैं, तो उनसे पूछते नहीं है कि कौन मर गए।
मर गए तो इसीलिए बताया कि मर गए, जानकारी नहीं है पूरा कौन कौन क्या हुआ।
पूरा कौन कौन क्या हुआ जानकारी नहीं है,
या-
यही फोन करके बताया उसने कि उसको जानकारी नहीं है कि कौन कौन है, क्या क्या नहीं है। ये किस तरह का इंफॉर्मेशन है, कौन कौन मर गए हैं पता नहीं है।
आता है जो हम लोग पास होता है, जिस तरह से बोलता है उस तरह से बोल नहीं सकते।
जिस तरह से वो बोलते हैं ना,
कुछ हम
उस
लोग भी
तरह से
समझ-
आप नहीं
हम
बोल
लोग भी
सकते।
समझ में नहीं आती है।
यही लिखा दें कि कौन कौन मर गए हैं पता नहीं है, लिखा देते हैं, केस डिसमिस कर देंगे इसी ग्राउंड पर। कुछ लोग मर गए हैं लेकिन पता नहीं है कौन कौन मर गए, इसी ग्राउंड पर डिसमिस कर देंगे। आप रेस्टोर करा के लेके आइएगा इस मैटर।
मरा हुआ आदमी कहाँ गए?
कौन मरा हुआ?
ये लोग ना बहुत गरीब आदमी जा नहीं
गरीब
सकता है।
आदमी को और गरीब मत बनाइए। गरीब आदमी को ना अपने विजडम से, अपने नॉलेज से उसको अमीर बनाइए, उसको और गरीब मत बनाइए।
इधर से काउंसिल है, उनके इन्फॉर्मेशन दे सकते हैं।
क्या इन्फॉर्मेशन देंगे वो? आप बताइए ना कौन मर गया, आपको कुछ इन्फॉर्मेशन है?
इन्फॉर्मेशन है कि कहीं मर गए हैं।
आपको कोई इन्फॉर्मेशन है?
इन्फॉर्मेशन है कि लोग मर गए हैं।
कौन लोग मर गए?
बाबूलाल के दीगर है जो सब्स्टिट्यूटेड है वो मर गए हैं।
किसके
वैसे-
सब्स्टिट्यूटेड? कई सारे सब्स्टिट्यूशन हो चुके हैं इसमें, आप हमको बताइए किसके सब्स्टिट्यूटेड। बाबूलाल के नाम से तो कोई आदमी नहीं दिख रहा हमको इसमें। कौन है
फर्स्ट
बाबूलाल?
रिस्पोंडेंट
फर्स्ट रिस्पोंडेंट थे ना, वो 2003 में मर गए। उनके स्थान में वो लड़का, दो पत्नी और बेटी, ये 4 सब्स्टिट्यूट हो।
फर्स्ट रिस्पोंडेंट तो अभी तक बाबूलाल मुर्मू तो सब्स्टिट्यूट नहीं हुए।
नहीं है।
बाबूलाल मुर्मू सब्स्टिट्यूट नहीं हुए हैं। बताइए, लिखा है बाबूलाल मुर्मू हैज एक्सपायर्ड। आपको नहीं पता है सर, आपको भी कुछ नहीं
हम
पता
तो कह
है।
रहे हैं ना आपको,
किसका
हम
डेथ
तो
हुआ?
कह रहे हैं कि बाबूलाल मुर्मू का जो है उसमें उनका डेथ हुआ तो आईए नंबर पड़ा।
इसमें आइए पड़ा है।
इसका आईए पड़ा सब्स्टिट्यूशन के लिए।
अच्छा,
वो आपका वो ग्रीन लगा हुआ है, उसमें फ्लैग जहाँ से देखा जाए उसमें दैट इज द एप्लीकेशन।
आइए नंबर
ऑर्डर नंबर 6 पढ़ा जाए तो ऑर्डर नंबर 5 पढ़ा जाए। ऑर्डर नंबर 5 डेटेड 25/2/2003, इसको जैसा देखिए उसमें है इशू सो कॉल्ड नोटिस एज टू व्हाई दे शुड नॉट बी सब्स्टिट्यूटेड या क्या था, ऐसा है देखिए।
इसका क्या हुआ? ये आइए पेंडिंग है क्या? 263 ऑफ 2003। ये कब डिस्पोजल हुआ? आइए डिस्पोजल कब हुआ सर?
एक और आदेश और देखा जाए,
बताइए।
ऑर्डर नंबर 6 देखा जाए तो 1/5/2003 का, जिसमें हमारे तरफ से ऑब्जेक्शन हुआ, इनका केस जो है एवेट हो गया है। इसमें कॉम्पिटेंसी ऑफ द अपील शैल बी कंसिडर्ड एट द टाइम ऑफ हियरिंग।
उसके बाद
अब
उसके बाद कुछ
इस
भी
पर
नहीं हुआ।
आदेश हुआ कि नहीं, दे हैव बीन सब्स्टिट्यूटेड का है कि हम मेमो में नहीं देखते हैं कि वो सब्स्टिट्यूशन हुआ। पर्सन में है लेकिन बाबूलाल में वो चीज़ नहीं देखते हैं मेमो। उनको करना था मेमो, उनका है।
इसमें कभी रेस्टोरेशन कोई फाइल हुआ था क्या? आइए नंबर 1325 क्या है?
इसमें पहले दूसरे काउंसिल के बाद में लोग आए।
बहुत अच्छी बात है। उस दिन बाद जो है ना, ये जब दुनिया खत्म हो जाएगी तब इस केस को पढ़िए। देखिए ऐसा है कि आपका इसमें it has already abated so far as incompetence of the matter as memo of appeal stood abated as against the legal year by the order dated 1/5/2000। इसीलिए आप उसका तो मरने का कहानी मर चुका है, उनके मरने का कहानी भी अब मर चुका है क्योंकि 2003 में ही अबेट हो चुका है, राइट। अब आप हमको ये बताइए कि इस अपील में आपको क्या रिलीफ दे सकते हैं जब रेस्पोंडेंट नंबर 1 का डेथ हो, because there is an order that this will be considered at the time of
बोले
hearing।
एक मरा है 10/5/2025 को
कौन बोल रहे हैं?
इधर साइड।
वो बोल रहे हैं, आप सुनिए, हम तो रिकॉर्ड देखेंगे। वो बोल रहे हैं, आप सुनिए, आपके कहने से नहीं दिखाएंगे, रिकॉर्ड से लिखेंगे, ठीक है ना। तो रेस्पोंडेंट नंबर 1 का डेथ हो गया। अब बताइए ये अपील का अबेट कर दिया पूरा कि पार्टली अबेट किया? बताइए, आपने कुछ पिटीशन फाइल किया ऐसे? नहीं फाइल, ठीक है। बताइए हु इज रेस्पोंडेंट नंबर 1? हु इज रेस्पोंडेंट नंबर 1? Respondent first set, correct? What was the suit for? Legally, plaintiff is the legally adopted son of Munshi Murmu, right?
महीने का टाइम दे दिया इसमें प्रॉपर से सब कुछ करने।
क्या चीज?
2 महीने का टाइम दे दिया प्रॉपर से सब कुछ करने।
2 महीना नहीं, आपको 20-25 साल का टाइम दे दो ना। हम रहेंगे, आप तो रहिएगा, हम नहीं रहेंगे। नहीं, 20-25 साल में तो मेरा तो राम नाम सब तो हो ही जाएगा पक्का। देखिए एडॉप्शन का केस है ना सर, पूरा सूट अवेट नहीं करेगा
जी,
इसलिए बहस कर। लाइए रिकॉर्ड दीजिए तो। और तो किसी का मरने का कहानी नहीं है, हो गया?
वार है।
कौन मर गया बताइए, नाम बताइए, और किसने आपको खबर? कौन मर गया?
बूढ़ो बूढ़ो मुर्मू रक्षम 4 और 5।
4 और 5 आपको किसने इन्फॉर्मेशन दिया कि ये मर गया?
वही जो जस्ट आए थे ये महेंद्र मुर्मू प्रथम मुर्मू के बेटा।
राजेंद्र मुर्मू, वो पार्टी है यहाँ पर?
महेंद्र मुर्मू अभी जस्ट सब्स्टिट्यूट हुए हैं, अपना के बेटे हैं।
महेंद्र मुर्मू ने आपको ये खबर दी है?
जस्ट अभी खबर दी इसी मंथ
इसी
मंथ
मंथ कि रेस्पोंडेंट नंबर 4 और 5 का डेथ हो गया। कब मरे हैं नहीं पता है, तो 1 साल 2 साल 2 महीना 15 दिन ऐसा तो कुछ पता, टेंटेटिव तो बताए होंगे ना।
लगता है बाहर में कमाता खाता है, उसको पता नहीं कब मर गया क्या हुआ डेट तो उसको पता नहीं।
आपके पास इनका वकालत, आप अपील करते हैं रिस्पॉन्ड नंबर 4 और 5 की तरफ से रिस्पॉन्डेंट?
हम तो परफॉर्मा रेस्पोंडेंट हैं, हम कैसे तो कंटेस्टेड रेस्पोंडेंट परफॉर्मा यही नहीं का पार्टी है।
ये तो आप ही के रिश्तेदार हैं।
प्लेंट में इनका परफॉर्मा
तो फॉर्मा आप ही के रिश्तेदार हैं ना ये? यस, अपीलेंट, दे आर योर रिलेटिव्स। लिखा देते हैं that these two persons have died and you have received this information from महिंद्र मुर्मू। तो क्या करेंगे? कितना टाइम चाहिए?
8 दिन का दिन।
8 महीना के आपको 2 साल का टाइम देंगे, तब तक 2-4 लोग और मर जाए। कुछ शर्म नहीं आता बोलने में? 8 हफ्ता चाहिए आपको?
अभी जस्ट मरने के बाद तो हम सब आए हैं, पहले तो थे ही नहीं।
कौन आए हैं मरने के बाद?
तुम प्लांट के मरने के बाद हम आए
एडवोकेट ना?
हैं।
तो क्या
पहले
करेंगे?
तो थे भी नहीं।
लिटिगेशन तो चलते रहेगा, आप रहिएगा, कल कोई और भी रहेगा, फिर सुप्रीम कोर्ट में कोई और भी रहेगा। वकील से पार्टी पोजीशन थोड़ी चेंज होगा। दो हफ्ता से ज़्यादा का हम आपको टाइम नहीं देंगे, और टाइम अगर चाहिएगा तो आइए फाइल करिए, आइए।
कभी फाइल नहीं कर पाएगा, इतना गरीब है। यही तो
इतना
फाइल
गरीब
किया है,
है।
मुश्किल है, नो होगा नहीं पड़ा टाइम के लिए आइए कहाँ देगा।
आइए आइए
बहुत गरीब है, बहुत आ नहीं पाता है, लोग आने के लिए भाड़ा नहीं होती, तो किसी किसी दिया है, फाइल किया था सब चीज़ अब विश्वसनीय कर तो देख रहे हैं चीज़
समझ। लीगल एड के पास भेज देते हैं, वो तो है ही नहीं ना। आप जाइए लीगल एड में, गरीबी के नाम पर उनको पूछिए, बोलिए कि इसको इनको लीगल एड का ज़रूरत है। वो लोग अपना दूसरा वकील एंगेज करेंगे, जो लीगल ईयर्स होंगे रेस्पोंडेंट के, वो अपने दूसरा वकील एंगेज करेंगे। इसमें क्या करना, वो तो दूसरा ही वकील एंगेज करेंगे ना, आपको तो नहीं एंगेज करेंगे।
हट जाएंगे इससे भी कुछ।
आप तो अपीलेंट को रिप्रेजेंट कर रहे हैं ना, तो आप प्रोफॉर्मा को कोई और रिप्रेजेंट करेंगे लीगल एड से। तो लोग को लीगल एड के पास भेज दीजिएगा, गरीब आदमी।
ये गरीबी है, ये गरीबी है।
ऐसे नंबर 185 ऑफ 1995, द लर्नेड काउंसिल फॉर द अपीलेंट। नाम बताइए अपना? कौशलेन प्रसाद। On instructions from Mahindra Murmu, has submitted that respondent number 4 and 5 have expired, but he has no knowledge about the date of death of those respondents. The learned counsel prays for time to take appropriate steps. Post on 8th of September.
उसके बारे में लिखा के रेस्पोंडेंट नंबर 1 का जो ईयर्स मिला है,
अब तो वही रिकॉर्ड पर ही
उसका भी जो सब्स्टिट्यूशन उनको करना पड़ेगा।
कैसे सब्स्टिट्यूशन करना पड़ेगा? अबेट कर दिया, हम इतना डिले हम कंट्रोल थोड़ी करेंगे। मर्जी वो करें, हम तो रिजेक्ट कर देंगे।
वो तो होगा।
ऑर्डर शीट में जो चीज़ दिख रहा है 2003 में अबेट कर गया प्रोसीडिंग, हम नहीं अलाउ करेंगे।
Item 2, second appeal 4 of 2000.
I'm only dictating the judgment.
So while your lordship dictate the judgment,
I don't want to hear
I
anything
would
more.
request that your lordship keep in mind section 100, subsection 5 proviso of the CPC.
The arguments have already been recorded as concluded.
Yes, yes.
Yes.
I'm not arguing.
So,
The provision of law is a power with your leadership.
that's right.
Our
Which
proposed
is second appeal number 4 of 2000. The arguments of this case was concluded yesterday. The matter has been placed before this court for dictation of judgment in open court. This appeal has been filed against the judgment dated 15/9/1999 within bracket decree dated 11/10/1999 bracket close passed by learned first edition district judge Godda in title appeal number 34/1 of 1983/99 affirming the judgment and decree dated 6/8/83 passed by learned subordinate Judge Godda in title suit number 31 of 1978. The suit was decreed and the appeal has been dismissed. The defendant is the appellant before this court. This appeal has been admitted for final hearing by the order dated 12/10/2017 on the following substantial questions. Quote. The suit was filed seeking a declaration that the defendant number 1, Mrityunjay Pandey, was not the adopted son of Mausama Mugia Devi, widow of Sukhdev Upadhyay, on 18/5/78 or at any other time, and that he is not the adopted son and that the adoption deed dated 27/5/1978 is void, illegal, fraudulent, and inoperative. While referring to the first substantial question of law, the learned counsel for the appellant has heavily relied upon Section 16 of Hindu Adoption and Maintenance Act. To submit that, ये दीजिए, Hindu Adoption and Maintenance Act. To submit that, there is a presumption in connection with a registered deed of adoption, and the presumption extends to the performance of the necessary ceremonies for the purposes of adoption. The learned counsel submits that the deed involved in the present case being a registered deed of adoption, there was presumption in favor of the defendants, but it was for the plaintiffs to prove that there was no valid adoption in the eyes of law, and therefore the entire approach of the learned courts in dealing with the matter of adoption supported by a registered deed of adoption is incorrect, and the burden of proof has been wrongly put upon the defendants to prove adoption. The learned counsel submits that it was for the plaintiff to disprove adoption, which they have failed to disprove, and therefore, on the face of the registered deed of adoption, the first substantial question of law is fit to be answered in favor of the appellant and against the respondents. The learned counsel has placed the deed of adoption and has referred to the judgment passed by on the Supreme Court reported in bracket 2013, bracket close 4 SCC 97, and has submitted that mere technicalities cannot defeat, and has referred to paragraph number 22.1, the 21, sorry, paragraph number 22.1, (22.2), (23), (24) and 25, and then para number 31. To submit that in the to submit that the document of adoption has to be considered as a whole, and real intention of the parties is to be looked at, and merely because the mother and father had, or the natural mother and father of the child had put their signature on the adoption deed, on the registered adoption deed as witnesses. Both have signed, no? Both have signed, mother and father. Mother and father both have signed on the registered deed of adoption as witness. The same was not fatal to the legality and validity of deed of adoption. The learned counsel submits that basic ingredients of adoption, like the date of adoption, the handing over and taking over of adoption of the child by the adoptive mother, which was given by his, it was handed over to her by the natural parents, have been duly recorded in the deed of adoption. The learned counsel has also submitted that in the deed of adoption it has also been recorded that the required home was also performed. Home या पूजा लिखे?
Datta home is the language used in that.
Datta home.
Homo.
Datta homan was also conducted. इसमें एरर मत करिएगा नहीं तो जजमेंट हो जाएगा गलत.
दत्तक होम लिखा हुआ है language.
दत्तक होम was also performed.
पूजा पाठ एवं दत्तक होम.
पूजा पाठ, दत्तक होम, etc.
आदि विधि.
etc. ceremonies were also performed. The learned counsel has submitted that the first substantial question of law be answered in the favor of the appellant and against the respondents. So far as the second substantial question of law is concerned, the learned counsel submits that the impugned judgment suffers from perversity कौन-कौन से विटनेस हैं of the locality?
DW2, 4 and 8.
Suffers from perversity in the matter of appreciation of three witnesses, namely DW2, 4 and 8. Whereby the learned courts have disbelieved the story of adoption on the ground that no non-Santhal witness to the adoption ceremony have been produced. He has submitted that the DW2 कौन था?
DW2 was.
Defendant number?
DW2 तो defendant नहीं तो locality का witness है.
अच्छा नहीं हो सकता है डिफेंडेंट नंबर भी कोई हो नेबर है
नहीं डिफेंडेंट्स में तो सिर्फ the adopted child and the natural parents.
DW2 has stated in paragraph किस पैराग्राफ में बोली?
His chief. Paragraph 1, 2. One and two of chief.
Paragraph 1 and 2 of the chief. That
One he said that मृत्युंजय को गोद लिया था और टू में बोला गोद लेते समय हम थे पीफे को गोद लिया मुंगिया के गोद में जयंत पांडे और उसकी जनाना ने मृत्युंजय को उठाकर गोद में दे दिया.
नहीं इसका बात नहीं कर रही. ये देखिए आपका है कि adverse inference has been drawn with respect to non-examination of non-Santhal persons.
वो इसलिए कह रहे हैं कि ये तीन संथाल है बस. That's it. खाली संथाल क्यों?
The learned counsel has submitted that DW2, 4 and 8 had duly supported the factum of adoption and the ceremonies performed but their witnesses have been rejected. Their evidence has been rejected only because they were non-Santhal persons.
And some other discrepancies. Because he lied about some other discrepancies. Once only.
The learned counsel appearing on behalf of the, बस इतना ही है आपको और कुछ बोलना है बताइए आप इन पर्टिकुलर पैराग्राफ नंबर सच क्योंकि वो जब लिखाएंगे तो उसमें लिखाएंगे ना रिपीटेशन नहीं पैराग्राफ नंबर खाली बता
इनका witnesses तो खाली चीफ है जो है.
अच्छा
पैराग्राफ नंबर लिखने से वो कंफ्यूजन होगा. क्रॉस पैराग्राफ नंबर से चीफ इज ऑल इन वन और टू पैराग्राफ्स.
The learned counsel has further submitted that
चीफ का पैराग्राफ करके लिख लिया जाए.
हाँ बताइए.
तो EW2 का पैराग्राफ 2 चीफ का 2 और EW4 का पैराग्राफ चीफ का पैराग्राफ 1
EW8
paragraph 1.
The learned counsel has in particular referred to paragraph examination in chief of DW2, 4 and 8. Paragraph 2, 1 and 1 respectively.
क्रॉस DW8 का क्रॉस का रॉन्ग इंटरप्रिटेशन किया गया है. पैराग्राफ 2 में जो क्रॉस था उसमें लिखा हुआ था कि बच्चा को मुंगिया की गोदी में देखा, प्रसाद खाया और चल दिया. सो कोर्ट हैज इन्फर्ड कि उसके पहले का कुछ देखा ही नहीं. जो चीफ में देखा दैट हैज नॉट बीन बिफोर.
By referring to cross examination of DW8 at paragraph number paragraph 2 of cross examination, he has submitted that the statement made therein has been selectively referred to without referring to the entire evidence of DW8 who had seen the entire ceremony of adoption.
पूछने का तरीका पर होता है ना. पूछे नहीं जवाब दिया.
DW8 का ना देखो हैं. DW8 जो पैराग्राफ 2 में बोल रहा है या कम जयंत पांडे ने या मुंह में अग्नि जयंत पांडे दिया. DW8
The learned counsel
दुनिया को जानते हैं. बेटा को 3 वर्ष भूखे को रात में गोद ली. रात में
the learned counsel has submitted that irrespective to the answer of substantial question number 1, if the evidence of non-Santhal persons, that is DW2, 4 and 8, are taken into consideration, the adoption was due. He has submitted that the parents and other close relatives who had participated in the adoption ceremony had also supported the case of adoption, and there were other witnesses of the locality to support the case. यही है. उतना तो आपका substantial question of law नहीं बनना है. हाँ, the learned counsel has also submitted that even the Purohit who had PW17 who had performed the adoption ceremony was also examined, but his witness has been rejected solely on the ground that he was an educated person and was a teacher
doctor
and was a doctor.
was practicing
and was a
practicing
Hakim.
Hakim word. In the quite word is Hakim. Practicing medical profession.
And was pursuing medical profession.
While in cross examination, he said that his father was the priest 2 years ago he died.
Although in his cross-examination he has stated that the father of DW17
And he the priest.
was the priest who died 2 years ago and 2 years prior to the adoption ceremony.
All this has not been referred to in the judgment.
The learned counsel appearing on behalf of the respondents
Relatives का DW बोर्ड का नहीं लिखा.
कौन से
Relatives का 5 and 9.
5 and 9
5 and 9. They have been rejected solely on the ground that they are relatives.
and father and parents का
Natural parents का. PW1 है father, mother नहीं.
DW1.
DW.
DW1 is the father, natural father of the plaintiff, of the
The
child,
child.
and DW5 and 9 are the close relatives who have fully supported the factum of adoption, but their evidence has been discarded only on the ground that they are close relatives and interested witnesses. The learned counsel appearing on behalf of the respondents has opposed the pair and has submitted that the learned courts have fully considered the materials on record and the registered deed of adoption was not found in accordance with Section 16 of the Hindu Adoption and Maintenance Act by both the courts, and therefore there is no question of any presumption in favor of the appellant. The learned counsel submits that once the registered deed of adoption was not in accordance with Section 16, the learned courts have rightly put the onus upon the defendants to prove the factum of adoption once the adoption was challenged by the plaintiffs in the suit. Correct? The learned counsel has also submitted that both the learned courts have considered all the materials on record and therefore, and in absence of any perversity in the matter of appreciation of evidence, there is no scope to answer, there is no scope of any interference. In view of the aforesaid submissions, the learned counsel has submitted that both the substantial questions of law be answered against the appellants and in favor of the respondents.
उसमें एक जो हमारा सबमिशन था कि माइनर के बारे में कोर्ट दोनों को पूछ रहा है कि माइनर कुड नॉट हैव एंटर्ड इनटू एग्रीमेंट. वो कहा कि लेगधारी में माइनर है.
The learned counsel has submitted that the learned counsel has submitted that in the registered deed of agreement, in the registered deed of adoption, it is the minor, the so-called adopted child, who was one of the party. He submits that a minor could not have entered into any kind of agreement for adoption. The deed was to be necessarily prepared between the adoptive mother and the natural parents. But this defect of the deed has been recorded by both the courts, and both the courts have held that the deed was not executed as per law. He submits that no substantial question of law has been framed with regard to the aforesaid concurrent findings recorded by both the courts with regard to the legality and validity of the registration of the deed in terms of the provisions of section 16 of the Hindu Adoption and Maintenance Act. यही है आपका? That's all.
फाइंडिंग है उसमें
He submits that there are concurrent findings recorded by both the courts. This appeal is fit to be dismissed. After hearing the learned counsels appearing on behalf of the parties, this court finds that the specific case of the plaintiff was that one Rajpal Upadhyay had 3 sons. And Mausamar Mungia, widow of one of the sons, was childless. And that she had no surviving relation in her parental side, as she was the only issue of her parents. She, being the granddaughter of Srijat Pandit, inherited his properties. The defendants were said to be resident of village Lachinta, where Mausamat Mugia Devi had her maternal grandfather's house. She was a child widow and her husband died around 50 years back without leaving any issue. And she died on 18/10/1978. The case of the plaintiff was that Mausamar Mugia had not adopted any child and never intended to adopt anybody. It was false to say that she had executed a document of adoption, adopting the defendant number 1. The plaintiff came to know that defendant number 2, being the resident of village Lachita, intimately knew Mausamat Mugia Devi and managed to bring her to Godda to render some monetary help for treatment of her illness. and Mohammed Nogia had requested defendant number 2 for a loan of rupees 200, which he agreed to pay provided a registered bond was executed in favor of defendant number 2. Mohammed Nogia agreed to take loan by executing a registered bond, and she was duped in the month of Baisakh 1975 by defendant number 2. And after more than 3 years, that is on 27/5/1978, she was brought to the registry office, and in collusion with the deed writer, the defendant number 2 got registered deed executed through deed of adoption executed through misrepresentation and by practicing fraud. And the deed writer put LTI of Mungia Devi over the deed, over the registered deed. It was a case of the plaintiff that she never adopted, Mungia Devi never adopted defendant number 1. And the entire story of religious ceremony of giving and taking over of the child, said to have been conducted on 18/5/1978, are all imaginary and fictitious, and no ceremony at all had taken place on 18/5/78 or at any point of time. With this background, the registered deed of adoption dated 27/5/1978, mentioning the adoption ceremony performed on 18/5/78, was sought to be declared as null and void. The defendants contested the suit, and the fact that Mungia Devi was a widow and further relationship as narrated in the plaint was not in dispute. It was stated that the persons in her in-laws' place totally neglected her and kept no connection with her, and somehow she managed herself in her nanihal. She had inherited her father's property, and defendant number 2 was her relation from Nanihal. It was asserted that Mohammed Mungia developed love and affection for defendant number 1 and opted to adopt him as her son. She expressed a desire before defendant number 2 and 3, who were her parents, such request was duly accepted by defendant number 2 and 3. It was a specific case that a formal ceremony was organized in the house of Mohammed Mungia on 18/5/1978, and in presence of villagers and her family, Purohit and defendant number 2 and 3 gave the defendant number 1 to Mohsamad Mungia Devi, who accepted and took him in her lap and proclaimed him as her adopted son. And since then, defendant number 1 was living with Mohsamad Mungia. Thereafter, Mohsamad Mungia voluntarily executed the deed of adoption on 27/5/1978, in which the defendant number 2 and 3 had put their signature as witnesses. It is not in dispute that Mohsamad Mungia Devi died on 18/10/1978. It was asserted that she was in perfect health and mind and she was never ill. The story of raising loan of ₹200 from defendant number 2 and other stories regarding fraud in the matter of execution of adoption deed was denied by the defendants. Defendant asserted that defendant number 1 is the legally adopted son of Mohsamad Mungia and after her death he had performed Mukhagni Kriya and had performed the Shraddh. It was also asserted that the adoption deed was valid, genuine and legal. The following issues were framed by the learned trial court. By deciding issue number 5, the exhibit B was a registered deed of adoption dated 27/5/1978. It was executed by Mohsamad Mungia. It was said to have been executed by Mohsamad Mungia in favor of the adopted child, namely Mrityunjay Pandey. Section 16 of the Hindu Adoption and Maintenance Act is quoted as under. The trial court, while considering the registered deed of adoption, has scrutinized the deed of adoption itself vis-a-vis the provisions of Section 16 of Hindu Adoption and Maintenance Act. And observed that the adoption deed within bracket exhibit B suffers from certain lacuna. The deed was executed by Mohsamad Mungia in favor of Mrityunjay Pandey, the defendant number 1, the adopted child. The learned court observed that defendant number 2 and 3, who are the parents of defendant number 1, are not the executants of the document, and Mrityunjay Pandey, being a minor, could not have entered into an agreement, and it was necessary for their parents to execute the document in question in token of the fact that they have made physical delivery of the boy to the adoptive mother. It was also observed that the fact that defendant number 2 and 3 made signature over the deed in question did not make them executants. The trial court held that it could not, in view of such fallacy, it could not be presumed that the adoption was made in compliance with the provisions of the Hindu Adoption and Maintenance Act. However, the learned court, after having held as aforesaid, was of the view that the oral evidences regarding adoption was required to be considered, and since the deed of adoption was not in accordance with the provisions of section 16 of the provisions of the act, the court observed that the onus was very heavy upon the defendant to prove the adoption. This court finds that the learned first appellate court has also considered this aspect of the matter and has held in paragraph 7 that the person giving in adoption did not execute the registered deed of adoption. They have merely signed the registered deed of adoption as witnesses and was of the opinion that the learned trial court has rightly observed that the presumption under section 16 was not available to the defendants. The learned first appellate court in paragraph 7 has held that the observations of the learned trial court with regard to exhibit B was correct. Paragraph 7 of the learned first appellate court is quoted as under. The learned first appellate court also observed in paragraph 8 that even if presumption is available to the defendant, then also registered deed of adoption is not a substitute of giving and taking of ceremony, and the same was not the conclusive proof. This court finds that as per both the courts have taken note of the fact that the natural parents of defendant number 1 had merely signed on the deed of adoption as witness, and the child was a party to the deed itself. They had signed the deed as a witness and have recorded that the deed was not in accordance with section 16 of the Hindu Adoption and Maintenance Act. In view of the aforesaid fact, this court also finds that no such substantial question of law has been framed as to whether the finding of the learned courts that the registered deed was not in accordance with Hindu Adoption and Maintenance Act and therefore the learned courts were bound to consider the plea of adoption irrespective of the registered deed of adoption, and consequently the burden of proof with regard to adoption was certainly with the defendant who claimed adoption. The deed of registration of the registered deed of adoption having been held not to be in accordance with the provision of law cannot be used for the purposes of presumption provided under section 16 of Hindu Adoption and Maintenance Act. In view of the aforesaid facts and circumstances, this court is of the view that the learned courts have rightly put the burden of proof on the defendant who claimed adoption, irrespective of the fact that the deed of adoption was the alleged deed of adoption was registered, and this was so on view of the legal lacuna pointed out by the learned courts with respect to the registered deed of adoption, in connection with which no substantial question of law is maintained. Consequently, the first substantial question of law is answered against the appellant and in favor of the respondents. So far as the second substantial question of law is concerned, this court finds that before the learned trial court, before the learned trial court, the core issue in connection with the performance of ceremony of adoption on 18/5/78 was with regard to issue number 5. So far as DW1 is concerned, who is the father of the so-called adopted child, within that we defend number 1, he has fully supported his case but the learned trial court with respect to performance of ceremony on 18/5/78 and handing over and taking over of the boy by Mosammat Nuria, receiving him as son, but the learned trial court observed that this witness could not be considered credible unless some independent and reliable witness support his version and prove that actual ceremony was organized in which Mosammat Nubia adopted defendant number 1 as a son, and that there was actual giving and taking of the bond. DW2 was a Santhal witness. He claimed to have attended the ceremony of adoption and asserted that defendant number 1 was adopted by Mosammat Nubia. But with respect to Mosammat Nubia, who initially said that the adoption had taken place. Excuse me, I have a DB right now.
Item number 6.
अभी कैसे हमको DB?
Just the fact that there is a matter fixed at 5.
Just the fact that I have a DB right now.